Welcome to The Explainer. Today we're unpacking a really fascinating legal mystery. It's all about hidden home violations and the crucial and honestly sometimes totally painful fine print of real estate law. You know, if you've ever bought a property, or even if you're just planning to, you already know about the absolute mountains of paperwork involved. But what happens when the very laws designed to protect you contain a loophole so incredibly specific it basically feels like a trap? Well, today we're looking at a real-world case out of Arizona. Emry and Muriel Varhely versus the 8th Street Square Townhouse Association. It is a literal masterclass in why reading the fine print isn't just a good suggestion, it's an absolute necessity. All right, let's jump right in.
So imagine this, you're buying your dream home. You get the keys, you're excited, you start moving your furniture in, and bam, almost immediately you were slapped with a notice for an existing rule violation. A violation that was sitting right there before you ever signed the dotted line. Now, you'd probably ask yourself, wait, who is legally responsible for warning me about this? Shouldn't the HOA have said something? Well, as we're about to see in this explainer, the answer to that is way more complicated than a simple yes or no.
Okay, part 1, buying into an HOA. Let's look at the Varhelys and 8th Street Square.
You'll notice how incredibly fast things move in real estate, right? But man, they move so slowly in the legal system. In February 2012, the Varhelys signed a contract to buy a foreclosed townhouse directly from a bank. ING Bank to be exact. Just a month later, in March, the HOA provides the escrow company with what's called condo certs, basically a standard community disclosure packet, and escrow closes. Boom, the Varhelys are officially homeowners. But that honeymoon phase? Yeah, it didn't last. By October of that same year, after discovering these hidden violations, our frustrated buyers are filing a formal legal petition. It just goes to show how quickly a super smooth purchase can turn into a massive, massive headache.
And they weren't going to take this lying down either. Seeking some justice, they actually took the 8th Street Square Townhouse Association to an administrative court. They filed their petition with, get this, the incredibly specifically named Department of Fire, Building, and Life Safety, and they paid a $550 filing fee right out of their own pockets just to get the ball rolling. They really wanted the HOA held accountable for keeping them in the dark. Moving on to part 2, the alleged violation. What exactly were they claiming? Well, in their petition, they claimed the HOA explicitly violated a specific Arizona law, known as ARS, or Arizona Revised Statutes, Section 33-1806. The core of their argument was actually pretty straightforward. They said the HOA failed to provide them with a required specific statement alerting them to those existing property violations before the close of escrow. Basically, the Varhelys felt like they were led straight into a costly trap because the HOA withheld some absolutely crucial information.
But, you know, feeling wronged and actually proving it in court, those are two completely different things. Because this was an administrative hearing, the Varhelys had to meet a very specific legal standard. It's called the preponderance of the evidence. Now, you've probably heard the phrase beyond a reasonable doubt from all those true crime TV shows, right? But this is different. Preponderance of the evidence basically just means that the evidence, looking at it as a whole, shows that the fact you're trying to prove is more probable than not. It's essentially a 51% threshold. They just had to prove it was more likely than not that the HOA broke the law.
All right, Section 3, decoding the Arizona law. Time to read the fine print. Let's look at the exact text of Arizona Revised Statutes, Section 33-1806. It says, for planned communities with fewer than 50 units, a member shall mail or deliver to a purchaser a statement as to whether the records reflect any alterations or improvements to the unit that violate the declaration. Okay, so on the surface, this sounds like a total slam dunk for the buyers, doesn't it? I mean, someone definitely had to provide a statement about those hidden alterations. But I need you to look very, very closely at the 5th word in that quote, the word member. This is absolutely wild. The crucial point here is how the law actually defines that specific word. In a massive, completely counterintuitive legal twist, the Arizona statute defines a member strictly as the seller of the unit title. It does not mean the homeowners association itself. And, to make matters even worse for our buyers, the law explicitly excludes a trustee selling a property in a foreclosure sale from having to meet this requirement.
So that really leads us to the ultimate question. Why didn't the HOA have to disclose the violation? Let's trace the logic here. The seller was ING Bank. Because it was a foreclosure, the bank likely had absolutely zero knowledge of any physical alterations to the property that violated HOA rules. Meanwhile, the HOA did know, and they even provided some general condo certs documents to the escrow company. But they didn't provide the specific violation statement, so why on earth were they completely off the hook?
That brings us to part 4, the magic number. It's all about a strict cutoff. And that magic number? It's 48.
8th Street Square had exactly 48 units. Now, here's a super fascinating little detail that came out of the administrative judge's fact-finding. The units in this community were actually numbered 1 through 49. But because of superstition, there was literally no unit number 13. So physically, there were only 48 units in the entire planned community.
Believe it or not, this number built a perfect, bulletproof legal defense for the HOA. The law draws a hard line in the sand right at 50 units. If an HOA has 50 or more units, the association itself is legally forced to provide an affirmative statement about any violations to the buyer. But for communities with under 50 units, the law places the burden of disclosure entirely, like 100%, on the seller. Because 8th Street Square had 48 units, just 2 units shy of that legal threshold, the HOA had absolutely no statutory obligation to warn the Varhelys about those violations. None.
It basically created this perfect storm that completely blindsided the buyers. Think about it. The HOA did actually provide some initial condo search paperwork to escrow, and because they received some documents from the HOA, the Varhelys logically but mistakenly assumed everything was perfectly fine, and that the lack of a violation notice meant there were no violations at all. But remember the gap here. The seller was an uninformed bank that didn't know about the issues, and the HOA was a legally exempt entity that wasn't required to say a word. The poor Varhelys fell right into this massive, dangerous legal gap.
Let's move to Section 5, the final verdict.
The judge's ruling was incredibly decisive and totally devastating for the buyers. She wrote, "Petitioners failed to establish by a preponderance of the evidence that Respondent violated ARS Section 33-1806. Just like that, Judge Eigenheer officially dismissed the petition. She basically noted that it didn't matter what the bank knew or that the HOA handed over partial paperwork. Following the strict letter of the law, because there were only 48 units, the HOA had zero obligation to speak up. They followed the law exactly as it was written."
Following the judge's decision, the gears of the administrative machine just took over. On March 1, 2013, the judge issued her recommended order. Then, by law, the Department of Fire, Building, and Life Safety had a 35-day review period to either accept, reject, or modify that decision. Well, that period came and went in total silence. With no action taken by the department, the decision was officially certified as the final agency action on April 10th. The HOA's victory was totally cemented, and the Varhelys were left holding the bag on a property violation they never, ever saw coming.
Which leaves us with a really critical takeaway from today's explainer. When you're making the biggest purchase of your life, assumptions can absolutely be your worst enemy. I mean, do you know exactly how many units are in your community? Because, as we've just seen, a difference of just 2 townhomes and a missing unit number 13 could completely change who is legally protecting your investment. You always have to verify the facts independently, demand explicit answers in writing, and never just assume that silence means you're in the clear. Thanks so much for joining me on The Explainer. Keep learning, keep questioning, and I'll see you next time.